Next you
I'm good.
take it. Yes.
Item 1.
In item 1, your lordship, day before yesterday, the matter was listed. Your lordship directed to file the custody certificate of the appellant, accused appellant. I have given the custody certificate, your lordship.
What was this?
Only 12 days was in inside custody. The conviction of the 1 year, your lordship.
What was this? Hmm? Report. Where is the order? Where is the order? Is not there. There. No. 16 days undergone, huh? 61 years, 1 year, 1 year, 2 months. Infant injured.
Lordship, 12 days, your lordship. 12 days you mentioned. 9, no, 3 din, your lordship. That is in second page of the brief. 12 days, your lordship.
Sorry, what do you want?
Lordship, the report is supplied by the senior superintendent of Circle Jail, Barampur.
Saying 16 days undergone only.
Yes, your lordship. It's 12 days, your lordship. 12 days, your lordship.
12 days.
Only this is 12 days. 12 days.
Where is it?
That is the third page of my report, your lordship.
Third page, huh?
Yes, your lordship. The actual sentence period undergone as per jail manual, A plus B plus B.
12 days.
Yes, your lordship.
12 days. 12 days. This matter was already heard?
Yes, your lordship. Day before yesterday, lordship, matter has already been heard, but your lordship directed to determine how much period is undergone by the appellant, your lordship.
Okay.
That effect, the matter is adjourned for the day, your lordship.
Okay. It was heard, no? Who was arguing for the
Junior counsel, Mr. Lalatin Sanantara?
I said that she is supposed to argue further.
Right.
1 year sentence, she is supposed to show something. Her evidence, huh? And keep it. She said, item 1, what happened? Why are you standing there? The matter is going on.
Item 1, I'm seeking for an adjournment, Your Lordship.
Sorry?
I'm seeking for an adjournment, Your Lordship.
Why? You have partly argued it.
Yes, Your Lordship.
See, now the report has come that you have only undergone 12 days, not 16 days. Only 12 days you have undergone, and you are 61 years of age. Partly heard.
Let's
clear. Next,
report is my report.
Next Thursday.
Yes, Your Lordship.
Get ready with the written note. Huh?
Report may kindly be in the report.
The report so has submitted to place on record a report indicating that the appellant has undergone 12 days sentence or 12 days custody. 12 days custody. Report is taken out about. Please give us for it. Yes.
Item 2.
Item 2, that is the Somoto correction of the nomenclature also.
Nomenclature?
The correction that Somoto lordships in CRA number 48 jagare eta CRLA heichi. That to be correct.
Which judge this judge beta? CRLA.
And CRA hoba katha hai, in fact.
Okay. Correct it and the front page. Here last year. Okay. Yes.
Item 3.
Yes. Yes, sir. What is the development?
Sir, divorce has been allowed by the lower court,
And
a permanent alimony was fixed by the Honorable Family Court as a permanent alimony, 10 lakhs. Sir, which I have filed in High Court for modification of that alimony amount. And Sir, Honorable Court has passed an order to deposit 2 lakhs directly to the court for remittance of quarterly payment to the Sir, at that moment of time, it was difficult on my part to arrange a full amount of 2 lakhs, which I have filed an IA.
There in that meta.
No, this case, sir. Sir, in this
Yes,
court
yes,
case,
uh.
sir, you have ordered to deposit 2 lakhs directly to the court, and the court will disperse the rest amount to the school directly in quarterly basis. Sir, I have filed an IA to modify as the school has a provision to pay in quarterly payment system.
Nay, what is the understanding there in the divorce petition about the child?
Sir, it was silent. That alimony was fixed, but the guardianship case is continuing.
So then the responsibility is yours now.
Yes, sir. I have already paid it. I have paid up to sir. Actually, it was 2,70,000 for the whole year. On that point of 16/4/2024, sir, 25, I have paid 70,000, and rest amount of 2 lakhs was due, which I was supposed to be paid for whole year amount, but the direction as per the direction of the Honorable Court. But sir, I have filed an IA to modify it to pay in installment. As it has been means sir, the matter was listed this one, but I have paid the 2 installment which was due on July and also in October.
The court can't sit and keep on doing all these things.
No, sir. It is
10,000, 5,000, 6,000.
No, sir. Already the payment is there is no due pending with the school, and also child is also going regularly to the school, and I have paid on July.
Yes, Mr. Das, has he paid
No.
the school?
It was a clear-cut direction that he should pay for 2 lakhs rupees, deposit 2 lakhs rupees before this
No,
court.
because
2 weeks.
this negotiation was going on, therefore I said that
Exactly.
at least you deposit 2 lakhs.
Since it
So
was an order of 16/4/2025. Now he is filing a modification on n number of grounds, whatever he says. The question now comes, and he has not given the copy of it. I don't know. I don't have an idea of what for he is coming. Then also now my question is whether this modification is possible. Neither the calculation is wrong, nor the order has been carried out.
Now, after this order, how much you have paid to this?
He has not paid a single buy.
Sir, I have already paid 1 lakh.
Why don't you give the copy? Then how will you understand it?
Sir, I have already filed. Sir, I'll give the right now to the sir. I have filed on 30th July.
See, ultimately,
Sir,
she's your daughter, you have to pay.
Sir, it's my
The idea
responsibility.
is 2 lakh rupees I told you to pay because that will be disbursed to the school.
Yes, sir. But sir, I have already paid 140 and another 68,492 rupees.
After this order.
Yes, sir. After this order, I have paid. Sir,
Yeah, whether he has paid or not, he should inform us.
You file,
Yeah,
give the
just come
copy,
in.
give
Yes,
the copy to
this
Mr. Das and let him
copy
understand.
and I-
Stipulate then.
sir.
Copy of the IA.
Next,
Yes, sir. I will give you, sir.
next Thursday. Let us see. You
Yes,
check it up and tell.
yeah. Thank you, sir.
Obliged.
But if the differential amount come with that money and to pay.
Sir, I attached.
All the time he used to come. He has become an. It is an attitude. It has become an attitude. He comes, he pays something, part of it, comes and says, "I paid it."
Now
this is the biggest question.
whether she has challenged the
Yeah.
divorce petition, divorce.
Yeah, it is pending. before this.
I have, and she is also.
It is
with
there.
the judiciary.
You are against the alimony, she is against the entire order, maybe.
Yes,
My lord.
Okay.
Thank you, sir.
Item 4.
Because called for a report from the HP as well as the IIC. So that Gosala matter, you know. I'm furnishing a report, you know.
What is the,
So they have,
it was found that
the cattle are with the
130
Gosala.
number of cattle have been received,
Yes.
comprising 29 numbers of cows, 17 numbers of so by pertaining to three issues.
Presently, the cattle are with the Gosala. The Jima number and the register of the Gosala is enclosed to the report of the IIC.
Now it is with Gosala now.
Gosala, yes.
Then there is no issue now.
There's no issue. The
Sir,
Jima-
we have located Gosala.
Yes, sir. Kindly see the application made by the the handing over of the cattle are given by the Jimadas, against whom the NBW order has been already been issued. And the first page is the register of the Gosala, which says on 18/8/2020, the serial number 2, Your Lordship. They have given
Total
142
out of that 10 died.
10 died.
132 is there with Gosala.
Gosala.
This
This is the
Okay. This is the report. Yes, on the basis of this report, now we have to
Yes.
see what can
Yes,
be done.
Yes.
Yes. Yes, acha, where is Miss? Yes, yes, Mr. Sahu.
My lord, sorry, my lord.
See
I
the
have
report.
not
See the
network
report.
problem issue.
Now there is a connectivity problem, I think.
I'm
Anyway, now there is a report by the SP of police
my lord.
that the cattle, 132 cattle are there with the Gosala, with
I
you.
am the petitioner's Gosala, ma'am.
That report has come. There is
My lord.
no now doubt that cattle are, where is the cattle? Cattle are
My
now
lord.
located, that is there with you.
My lord.
Now in view of this report, now what do you want to say?
My lord, what happened, my lord, in this case? I should kind of attention. 20
There is
Korea
some
second user job is up.
no, there is some connectivity issue.
Lord, I'm
Your voice
audible,
is
your
breaking.
lordship.
Shall I put it now? I'll relieve him and I'll take this report on record and the copy
My
will be
lord.
supplied to both of you, and thereafter we will see the.
I've already given the copy to the council.
You got the copy?
Mine.
You got. You have got the copy, Mr. Sahu?
Since he is
My
not
lord,
there,
they already visited our Gosala, my lord. We already
Okay.
informed that
Pursuant to the order
132 cattle.
23/9/2025, the who has given this report, madam?
one report is by the IIC R. Udayagiri, the other one is the SP
IIC R. Udayagiri police station has filed a report dated 5/10/2025, and also
16, Your Lordship. 16.
16,
The report is
16.
16.
2025, and both the reports are same.
Your Lordship, one is by the Superintendent of Police Gajapati and the other one is IIC R. Udayagiri, Your Lordship.
Superintendent of Police. No, the signature is
The last order, Your Lordship.
Acha.
Yes.
Police two reports. One by two separate reports dated
Yes.
6/10/2025. One by Superintendent of Police Gajapati and another by the IIC of Udayagiri PS Gajapati district, and which are taken on record. Conjoint reading of both the report indicates that the cattle are 132 number of cattle are found to be with the Sri Radha Madan Mohan Gosala. So and so it's like the para 2. The relevant part is para 2 of the which reads as that. The copy of the report applied to Council Mr. Maharaja as well as Mr. P.K. Sahu. Leaves the matter for hearing.
No, you'll see one more prayer.
Maybe-
Let me complete. The IIC, IIC, na?
Yes,
IIC, so it's not required to appear before
Much
the court for transport.
Much.
After
That is
the
my
report is being
That is
filed.
my.
Yes.
Lordship, their presence is much more required because different affidavits have been filed in different times and before different courts. Can we overlook that affidavit, Miller? By perusal of the present affidavit, can you overlook the other affidavit which has already been filed before this honorable court, before the honorable trial court?
Regarding what?
Regarding this issue? Regarding this issue?
No, this.
Wherever the cattle.
Now
how many
it
cattle
is
are
settled.
right?
This was.
Now it has
So
been.
because of there are a lot of confusion, lot of documents, lot of affidavit were
But
filed.
no
So therefore, I wanted that a consolidated report has to be filed by the SP. Now SP has to file it. Has to be believed.
There is no confusion. Look, they have filed the.
Are you
affidavit.
doubting the
Yes,
fact?
yes, that is my whole
Doubting
prayer,
the
Miller.
fact that the titles are not there.
Exactly, Miller, because they have filed the affidavit. They have filed the affidavit. ଏତିକି ଗାଈ ଅଛନ୍ତି ବୋଲି ସେମାନେ affidavit ଦେଇଛନ୍ତି ଆଉ ଏତିକି
So
ମରିଛନ୍ତି.
that I know that there was a confusion
That was the
because the IIC has joined recently.
The cat.
Earlier, IIC has given some report. So therefore, I asked the SP to file a report. Now SP has filed a report.
But-
You have to believe that report.
But I don't know. I don't my lord, say that that report whether it is right or wrong. I don't know.
Hmm.
I only draw your
You have to presume it to be correct because the SP has given.
the previous affidavit, my lord, the clarification.
Every affidavit, all the affidavits merge with this under the principle of merger. This is the final report.
Say affidavit over order he check. Say affidavit.
That's right. Now, after this order, this affidavit, this report, now the scenario is changed and accordingly all other orders have to be modified if required. It is again, on the basis of this.
Only prayer is their presence is required.
No, may I pray?
If required, I'll call. Don't worry. Online, because see,
Sir.
calling in a police officer at the cost of the service is not.
They should.
No, whenever it is
If required, I'll
Yes,
call.
yes,
Yes,
much
that is
But coming from Gajapati district, see, 2 days he might have spent.
not come. Many
It will
works
come.
there should have. I know what they are doing. I know.
Very difficult work there.
Let
Yes,
this be
I know.
heard, so whenever it is his.
And
judgment
whenever
is
a
required.
police officer is called, generally we feel sorry that we are wasting their time.
It's conducting. Person knows. And
So we'll relieve him.
Personally,
He
The
has
personal happiness
done
can
his
be
job.
dispensed.
We'll relieve him as and when required. I'll call.
Yeah.
Don't worry.
Much obliged.
As and when required, we definitely
My
will
lord.
have to, because he has to assist us. And if you want to file response to this report, also you are welcome.
no, I don't want to file in response. Only draw to your lordship kind attention. Many affidavit which has been filed before your lordship and before the tribal court and this present affidavit. What would be done
Are different.
on this affidavit? That is my only prayer.
The earlier affidavit has to be ignored in view of the report now.
Much obliged.
There is no option.
This is not the final affidavit. But what I want to say.
Then what do you want? Shall I call?
Your lordship.
I'll have to constitute an SIT for this.
No, for a moment. Your lordship.
Hmm.
For a moment. I don't.
What is your interest? Why are you?
Lord, I have already.
Your cattle are safe somewhere.
I'm
You should
satisfied.
be happy there.
I'm satisfied. I have already paid 2 lakhs rupees.
Now,
I'm unable to.
now the only thing is the who will pay the money for the upkeeping and maintenance of these cattle to the Gosala. That is the only issue to be
That is the
decided.
only thing.
We'll see what to do.
I have
My lord.
already paid 2 lakhs rupees.
My
As per
lord,
your-
may I submit your
2
lordship?
lakhs, what is the order? We'll see.
Total is 4 lakhs 29,000 as per the calculation made by the London Magistrate. I have paid
No,
2
no,
lakhs.
no,
That has
my
to
lord.
be-
It
I'm
is
having certified
totally
copy.
wrong.
That I'll hear. That I'll hear.
On the basis of the materials available on record, I am submitting. I am not submitting
no,
anything
sir.
out of record.
2 lakhs you have paid.
Sir,
That's what it
I
is.
have already
You have
paid 2 lakhs
filed
rupees.
your vakalatnama in any of the matters, sir.
Please,
Sorry to
please,
say,
let me submit,
you have
please.
not filed any
I
vakalatama in
have paid 2 lakh rupees.
60/20
As per
of
the calculation,
2025.
It is 4 lakhs 29,000 some odd. That is the certificate copy I am having. For a moment, your lordship, for a moment. 1 minute it will take.
How
Let's see.
how
This
it
is
is?
the
My lord,
calculation
last
made by the
occasion.
London Trial Court.
No, but
This
this
is the certified copy.
this
Can
calculation
I
was
say
made
out
on me.
of that? Do I have the power to overlook that order?
I think I have to set aside the
When
order
this honorable court
remand it back
repeatedly
for
asked him, my
recalculation.
lord,
in view of the
when
dump.
this
That
when
time it
this
was
honorable-
not,
Since
nobody was
cattle
sure.
Found, yes, sir.
Where was the cattle?
Cattle.
Now, since in view of this report, I'll have to send it back to the trial court for recalculation and to pass appropriate order
Yes.
in
My-
view of the judgment of this court. Jan Foundation judgment, on the basis of that, it has to be done. Because there was a
Yes, sir.
confusion. Where was the cattle and all? Now it has come.
Yes.
In view of this report, it needs to be decided to FRS. And the money which you have paid, that will be adjusted.
But what we decided, only the decision will be given, how much money will be given.
Under rule,
What
How much
expenditure has
and
been
to
done.
yes, under rule 5, it has to be calculated,
Exactly,
recalculated.
exactly. It has been already calculated that is as per the order passed by the London Trial Court.
I'll see that.
I'll get
But it is not only 40 cattle.
I can get that.
13, 27.
Your lordship, above your lordship, just first line.
No, no. Here just see. Here it is said Ranjan Mishra received 22 kettles, consisting to so and so, so and so.
Right.
Ganesh Panda received 40 kettles, and Manoj Paik received 40 kettles.
Yes.
All these issues. Now they say everything is with the Gosala. So this order has to go in view of this.
ସେମାନେ କି who are there? ମାନେ ଆପଣ ଏ ଲସିମେ can consider ଜିମାଦାର ତ rules ଅନୁସାରେ
Jimadars are gone somewhere. Jimadars have evaporated.
ତାହେଲେ ମୁଁ ତ କୁଆଡେ ଯିବି ମା
ଆଜ୍ଞା ଜିମାଦାର ମାନେ ଆଜ୍ଞା 18 8 ରେ ଦେଇଦେଲେ
Why are
ଘୋଷଣା
you worried? Your cattle are located now.
ନା I satisfied.
So why are you? The cattle are there in the Gosala.
Right.
The earlier position was it was given in Jima to XYZ. All of them evaporated somewhere. So therefore, I told by locate the cattle. I'm not interested in the Jima. Whoever has taken Jima, I'm interested in the cattle. Now they've located the cattle. That is there with Gosala. In view of this development, the order has to be a fresh order needs to be passed, and whatever you have paid, that will be adjusted. We'll see that. We'll see that. Yes.
Till then, may
Please.
kindly your lordship protect the,
Please.
Court protect.
What protection?
Yeah,
It is there with you. What protection?
my lord, the order passed by this honorable court in a CRLMC number 4435, that is still, they are executing that order.
Not
my lord.
Thursday. What I'm saying is Thursday. I'll hear it. You come physically. Physically,
My lord,
I'll
I am at
dispose it up.
hospital, your lordship.
Dispose it up. Okay. Next.
My
Yes.
lord, before dispose, my lord, I am saying, your lordship, the order of this honorable
Thursday,
court
I'll
not-
dispose. Not disposing now.
My lord, I am submitting, my lord. I am with your lordship.
Yes.
The order passed by this honorable court is not complied with in CRLMC number 4435. They have not added the Gosala as an opposite party. The notice also not sent to the.
But what see, they may implead or may not implead. But now you are there before this court. You are already the party. And while filing, while passing the final order, I'll have to take care of the report. The report says all the cattle are there with you. So
My
I
lord.
have to take care of that also. So
This
now you are
honorable-
already a party.
My
Already
only
party
concern,
before
my
this
lord, my only concern, this honorable court's order not complied by the petitioner. When this honorable court already directed, that is not complied. All the orders may kindly be complied. That is only yours.
Okay, Thursday I'll see if
My
I
lord.
pass the appropriate order.
2 ଲକ୍ଷ
My
ଦେଇଛି
lord.
ବୋଲି ଅର୍ଡର ହେଇଛି satisfy London trial court has given a report. The petitioner has already deposited 2 lakhs rupees.
We'll see that.
ଆମେ କୁଆଡେ ପଳେଇ ଯାଉନି ଏଥିରେ ସବୁ ଅଛି ଆମେ କିଛି ବାହାରୁ କହୁନି ମୁଁ ଯାହା ଅଛି ରେକର୍ଡରେ ମୁଁ ସେତିକି କେବଳ କହୁଛି
Now at this stage only we have to see that what will be the expenses for keeping the cattle, and you have to bear that expenses.
Yes.
For the state. That's the only issue.
ଆଜ୍ଞା
My lord.
Get into so many things. Let us see.
ଗାଈ ଦେଇ ଦିଅନ୍ତୁ ଯାହା ତାଙ୍କର ଖର୍ଚ୍ଚ ହେଇଛି ଯୋଉ
ଯାହା
ହିସାବ
ଖର୍ଚ୍ଚ ହଉଛି because ଗୋଶାଳା କୋଉଠୁ ପଇସା ଆଣିବ
ହଁ ସେଇଟା ତ ସତ କଥା
ଗୋଶାଳାକୁ ତ ପଇସା ଦରକାର ନା
ନିଶ୍ଚିତ
ସେଇଥିପାଇଁ ତ ରୁଲ ବନିଛି
ସେଇଟା ଠିକ
that is the only-
ଗୋଟେ ଗାଈର ଯାହା କାଲକୁଲେସନ ହେଇଛି ଯାହା ପଡିଛି
ସେଇ ହିସାବରେ
ସେଇ
after calculation-
ହିସାବରେ ଆମେ ସେଇ ହିସାବରେ ପଇସା ଦେବୁ କଣ?
calculation is instead of giving to that Mishra, Manoj, Padi and all, it has to be paid to Gosala.
ହଁ, ହଁ, ବାବା।
We'll see. That's a simple thing.
ଅଛି।
We'll see. I'll see that.
Grateful, your lordship.
ସେଟା କହିବୁ କାଇଁ କଣ ପାଇଁ କହିବୁ what gain will you get
What is the stage in trial?
trial କିଛି ଏବେ order ଦେଇଦେଇଛି lordship has paid already that London magistrate has prayed and directed the petitioner to approach before lordship once again because he is unable to comply the order passed by your
Because of
lordship.
this all confusion.
Yes, sir.
Because
So
of
the
all this
captors are
confusion.
from-
Now the confusion is put to rest now.
Yes, sir.
And things will be
Yes, sir.
okay. Thank you very much.
Grateful, your lordship.
Item 5. Item 5, my lord. I filed IA for modification. My lord, here,
Modification of what?
modification, my lord, subject to verification of antecedent. If it is found that petitioner has one criminal antecedent, my lord. And the petitioner was earlier on bail, my lord. By this.
What is the offense?
Offense 20, B2B, 2 kg, 100 gram, my lord.
So you are involved in similar case.
ତା ଆଗରୁ ଥିଲା ସେ ତାପରେ ଏଠି ପ୍ରଡକ୍ସନ ୱାରେଣ୍ଟ ରେ ତାକୁ ଏ କେସ ରେ ପ୍ରଡକ୍ସନ ୱାରେଣ୍ଟ ରେ ଆପ୍ଲାଏ କରିଲା ତ ତେଣୁ ସେଇ ପାଇଁକା
That's right.
Yes,
But in that case, what is the involvement?
involvement below commercial quantity has already released on bail. I have taken armament in my IA, that is 2ACC number 3 of 2025.
Why so many bail co-accused persons, huh?
Yes, my lord.
For the reasons stated in the application, the same is allowed. The order dated 22/9/2025. The condition imposed by this court in order dated 22/9/2025 regarding the release of the petitioner after verification of the similar incident is modified to the extent that the petitioner shall be released after the verification of the antecedent. Further verification of antecedent as to whether he is involved in any other case which is not disclosed before this court, before.
Goodwill केवळ one
This
antecedent.
modification, the application is allowed, yes.
Item 6. Please, my lord, modification, my lord. One antecedent.
What modification?
Subject to verification. Gote antecedent ache. I have mentioned para 3, my lord.
Para 3 of your application.
Yes, my lord. 20B 2B.
What is what happened to that case?
My lord, bail re ache.
Where have you
Trial.
shared that?
My lord,
Where have you shared that? Para 3 you have not shared.
he has on bail, my lord.
Bail,
Trial under
trial
progress.
progressing. And what is recovered from you in that case?
My
What
lord.
is the amount? What is the
Almost 7 kg, my lord.
in that case?
This case. This is, my lord, 4 kg.
Was same for the order for the reason stated in the application, the same is allowed. Well, allowed.
My lord, another thing, my lord, paragraph re year ta bhuli jaychi, my lord.
Submits that he has been falsely implicated in another case bearing number PS case number 91 of 2017, wherein 7 kg of contraband ganja is alleged to have been recovered, and he is already on bail in that case. And in your case, the how much? How much? What was the recovery in the other case?
That in other case, my lord, 10 kg, my lord.
10 kg and he's on bail. Okay.
33 would take it.
Next. 7.
But I'm appearing for the petitioner on behalf of Mr. Rautrai. I pray for an adjournment.
Okay. On the request on behalf of Mr. Rautrai, adjourned. Yes.
Appearance may be noted, minutes.
Yes.
My appearance may be noted. I'm appearing.
Yes.
Much obliged.
Item 8.
In this case, I am appealing for the
Okay. Please give your appearance to the.
Item 8, Your Lordship, I'm appearing on behalf of Mr. Subankar Raut for the petitioner, Your Lordship.
Sorry, madam.
I'm appearing on behalf of Mr. Subankar Raut for the petitioner, Your Lordship. He's in personal difficulty. The matter may be adjourned for 1 week, Your Lordship. That would.
You are appearing for Mr. Subankar.
Subankar Raut, Your Lordship.
Subankar Rao.
Yes, Lordship.
So appears on behalf of Subankar Rao, the counsel for the petitioner, and submits that due to personal difficulty,
Interim order.
he is not able to appear before this court, and hence an adjournment is sought. Accordingly, adjourned.
Interim order to continue. Your
Huh?
Lordship. Interim order to continue.
Interim order to continue. Interim order, if any, to continue. You are seeking adjournment because of interim order.
Your Lordship, he's in a personal difficulty.
But I'll vacate next time if you ask for it. It's made clear that no further adjournment shall be granted.
Earlier, this application before Lordship, serial number 2698/2022.
26?
2698 of 2022, Lordship.
What happened there?
Your Lordship, while your Lordship disposed of this matter, your Lordship directed to raise all the points, giving liberty to the prisoner to raise all the points before the Honorable Court below at an appropriate stage during the trial. And again, that the client, petitioner's
But
client,
again, he challenged.
before the Appeals Court.
That is the reason he's.
That's it, sir.
1 week after, Your Lordship, since I do not have the proper instruction.
That's it.
Okay. Yes.
Hearing matter. Item 9. The last.
Nobody was there.
Item 9. They should repeat it.
This appeal is pending since 1994. Nobody is appearing. Consistently, nobody is appearing on behalf of the appellant. And it was also indicated that if nobody appears, Amicus will be appointed for representing the appellant. Today, when the matter is called, none appeared. Therefore, so please take it. So appearing present in the court is requested to appear as Amicus curiae. And give the copy. And when can I put it? Next.
30. Item 10.
None. None.
So, there is noting is the state to obtain instruction regarding any.
Last order. State to obtain instruction. Got the instruction.
Also kindly pass over, but my order should
Pass
reflect
over.
that report receipt and.
Bus. Yes.
Item 11.
Item 11, Your Lordship.
Yes.
May I please?
Yes, madam.
Lordship will conduct the hearing today. I'm ready with the matter.
Will you do VC or you will come here? What do you want?
I'll do it in VC, Your Lordship,
VC. Okay.
if that's not an issue.
What is the offense?
Offense is under Section 7 of the Essential Commodities Act, contravening Clause 3 of the Odisha Pulses Edible Oil Seed and Edible Oil Licensing Order.
Yes.
Your Lordship, the case is that
What is the sentence?
sorry, Your Lordship,
Pay for 6 months and to pay
6 months and fine of ₹500.
Yes, madam. Tell me.
Yes. Your Lordship, the fact is that the complainant found 20 quintals and 59 kg, 500 grams of pulses of different varieties and 2.5 quintals of salt. Our whole case relies on the fact that the extra amount that is there in my godown, which was found, that is of other two persons, that is DW2 and DW3, Your Lordship.
BW?
DW2 and DW3, Your Lordship.
Acha.
Your Lordship, they have also placed their evidences when they were under when they were under evidence in the court below. They have.
What
also
the trial court says regarding that? Let us see.
Yes, Your Lordship. Page 15, Your Lordship. Your Lordship got it? Page 15?
Then seizure, you are not questioning the seizure. Seizure is there. You are admitting seizure. But you are
Seizure
saying
is
that the extra quantity belongs to
DW2 and DW3.
That's
Yes,
what you are.
Yes, Your
Let us see
Lordship.
313 also you have agreed that.
Sorry, Your Lordship.
In 313 statements also you have admitted that yes, it was recovered.
It was recovered, Your Lordship. But I am saying that the quantity that they are claiming is mine is not mine. I have
how the trial court deals with it. You say that these recovered quantities, whatever, has been and yes,
Yes, Your Lordship.
come to para 7 of judgment. DW1 states.
Yes, Your Lordship.
Hmm.
DW1 states that on 18/12/92 at about 6 a.m., the supply staff sealed the godown of the accused and called him while he was passing on the road and asked him to remain present near the godown at 9 a.m. So again at 9 a.m. he came there. The supply staff went to the residence cum shop of the accused and checked the shop room and then came to the godown where pulses of various types, salt and jaggery were found. At that time, accused claimed that those articles belonged to three persons, namely Sriram Murthy, Buji and himself. At the time of checking, those two persons arrived at the godown and demanded their articles. The supply inspector told them that the stock was already seized. He does not know the contents of the seizure list. He identifies his signature. He denies the suggestion that he signed on the statement of the accused after knowing its content, but now denies
Okay.
it.
What DW2 says?
Now, Your Lordship, DW2 says, DW2 states that on 16/12/92, he purchased 5 packets of arhar dal, 2 packets of chana dal, 3 packets so-and-so containing 49 kgs, 500 grams, and each bag containing 99 kgs. He handed over these stocks to a transport company for giving delivery at Sunabeda. On 18/12/92 morning, the accused came to his house and told that his articles reached Sunabeda at late night and he kept the articles in his godown and asked him to take delivery of the same. He gave him the bill of the consignment. At about 10:30 a.m., he went to the godown of the accused to take his articles and found the supply staff there. He showed the bill to the supply officer and wanted to take back his goods, but the supply officer told that the articles were already seized and advised him to approach the collector. He filed a petition before the collector, which is still pending. In cross-examination, he admits that his house is situated at a distance of about 2 furlongs from the godown of the accused. He admits that his articles have been booked in his shop address. He further admits that he does not possess any document regarding bringing those articles from Raipur. The collector passed order against him and he has preferred an appeal. Your Lordship, DW3 says the same thing.
What about DW2 3?
DW3 also states that on 16/12/92, he purchased 5 packets of so-and-so. He handed over the stocks to a transport courier at Raipur for giving delivery at Sunabeda, handing over the bill to that company. On 18/12/92 at about 6 a.m. in the morning, the accused came to his house and told that his goods arrived late night and kept it in his godown and asked him to take away the same. He went to the godown of the accused at 10 a.m. and found the supply staff. DW2 and others were there. He had received the bill from the accused, which he showed to the supply officer and claimed his stock. The supply officer told that the stock was already seized and he should approach the collector. He filed petition before the collector. He admits that he does not possess any documents regarding his purchasing articles at Raipur and handing over the same to the transport company. He claims that he has filed the bill and some other documents before the collector.
You come to page 19, para 10,
Yes, Your Lordship.
the paragraph. Similarly,
Yes, Your Lordship.
DW2 and 3.
2 and 3 have not called for the records of proceedings before the collector to prove that actually they have filed the documents of the purchase before the collector. Simply because they have filed petitions before the collector claiming ownership of pulses, it cannot be believed that they have filed the documents in that proceeding. Rather, the petitions have been dismissed by the collector. As I find, the accused has taken his plea that the stock belonged to 2 other persons at a belated stage to escape from the... Your Lordship, all I'm saying is that my stand is that the place at where the godown is a narrow lane. Therefore, they have dropped off the stock at my godown, for which I had asked them to collect it from my shop. I am saying is that when certain goods are in transit, they cannot be accounted for. My stock I can account for by giving the bills, but when somebody else's stock is in transit, they cannot seize that and they cannot be accounted for. I am saying that the learned court below should have taken into consideration the evidence that has been laid down by
Question is the stock of DW1, DW2 and 3. Why it was unloaded in your godown?
because your lordship, the truck was
See, the address given in the challan was their own address.
the
Your
address will
godown
be
address
given.
was not given.
Lordship, a very simple thing. Address has to be given there. Their go down address has to be given. If they were at that time, if there was any taxes that were being paid, they have to show it on their address. They cannot show it on somebody else's address.
Then how the delivery is done in
The
your
delivery
godown?
was given at their godown, at DW, at the accused's godown. Only reason because the lane was very small for the truck to enter.
Where will I get that land story?
Your lordship, at page 20.
20 yes.
Page
Read
20, it starts from the statement, your lordship.
Okay, yeah, this plea
Few lines
is
down, your
not
lordship.
tenable because if the lane was so narrow that no truck could enter into it, DW1 must have be aware of it. Then why their address was transport to company and so on so. That is what is the logic.
Your lordship, if I may place, page 18, your lordship, paragraph 10.
Yes.
In this case, the evidence of PW1, as I find, is most important. He is the magistrate and as such a responsible officer. Now, your lordship, I will like for you to peruse the evidence which is attached, your lordship. At page 28.
28,
your lordship, 28.
what is that?
This is the evidence of the officer, your lordship, PW1.
PW1, okay. Yes.
The cross-examination part, your lordship, paragraph 5.
Paragraph 5, okay. Yes, read it.
Some other shops in that locality were also checked that day. Now he does not remember if any other commodity was there in that shop, go down of the accused. If he is such a responsible officer and if he remembers everything, how can he not remember what other commodities were there?
Oh, that can't be.
He cannot say who were the neighbors of that shop. No police personnel accompanied them. He does not know if on that day the SP and the collector were camping at Sunabeda with the police force. All this has when the seizure was done, neither the collector nor police force were available at that moment.
Yes. Supply personnel engaged labor to bring out the seizure article. He does not know. Laying on the road and execution time to the
Your lordship, there is one more thing that I would like to bring to your lordship's notice.
Yes.
Your lordship, page 31. This is the examination of the prosecutor.
Yes.
Yes, your
Huh?
Sorry, your lordship. At page 31, your lordship.
Yes, paragraph.
Paragraph 4.
Yes.
He states that only that shop was checked on that day.
Oh, it was a for raiding the event they check.
Another point I would like to show your lordship. Page 32, paragraph 7.
Yes.
he admits that subsequently the accused and these two persons claimed their respective stocks before Collector Koraput in a 6 AEC proceeding.
Where is that?
At page 32, Your Lordship, paragraph 7.
He admits that subsequently the accused and those two persons claimed their respective stock before the Collector Koraput in 6AE proceeding, and he denies that he is suffering the effect. Yes.
All I am saying, Your Lordship, that there is a proceeding that had been filed before the collector. Even the prosecutor also is admitting it in his evidence. We have also stated the same thing. Both DW2 and DW3 are saying the same thing, that that was their stock because the truck was huge and it could not enter into a narrow lane. That is why the stock was dropped off at the accused.
Narrow lane thing, from which witness you have extracted?
Narrow lane, Your Lordship. It is discussed in the order, Your Lordship.
No, order, but from evidence, where from the you might have orally submitted, but from evidence, where will I get?
Yes, Your Lordship.
Have you suggested? Sri Ram Murthy is DW?
Sorry, Your Lordship.
Sri Ram Murthy is DW?
Yes, Your Lordship. DW2.
Who? DW, tell me the number.
DW2, Your Lordship.
DW2. And BG?
DW3 euros.
He's 3, Your Lordship. DW3.
The narrow line thing, where will I get it?
I'll just place you. Your Lordship, I have taken it, I have stated it in my facts. At page 5, Your Lordship, I have stated it in my facts.
No, but from evidence it has to, you have to get it. Not that orally something you are saying. That narrow lane thing, where from I'll get from evidence? The two things are going in their favor.
Stated that
One is both DW2 and 3. When the raid was going on, they went and claimed, saying that these are the stocks belongs to us.
that's it.
And DW3 even came and shown the bilty, saying that see, this is the consignment. It came in the midnight at 12 o'clock. And I was supposed to pick up in the morning, and in between you came and raided. That's what he says. And he shown the document. Thereafter, what happens is the same DWs have claimed these goods from the in the proceeding before the collector. So these are documented. It is not only orally, it is documented. But now I'm trying to find out the reason. What was the cause and what was the reason for which the stocks were put in the godown
No, not
instead
in
of delivering in the address given?
Lordship.
The address given was their houses. And what he says is a narrow lane in the godown is in the beginning of the land. So generally, whatever is being to be delivered, truck can't go inside. So therefore, it
Could
was
be unloaded
delivered
at that
there.
place.
He was only a custodian for a limited time. But where from I'll get that it was not possible to deliver the goods inside the houses or inside the shop of DW 2 and 3. Narrow lane thing, where from I'll get? Whether it's suggested or in 313 you have said? From where you have? Any suggestion to any?
Examination of the accused, your lordship, there is. Have you got anything more to say at page 26, your lordship? The
26.
thing is, it is written in Odia and it is not legible for me.
Question number 7, Your Lordship.
It is written in such a way that it's not
legible.
legible.
Odia, it's written. Let's see. 17 ବାର 92 ରେ ଟ୍ରକ୍ ରେ ଜିନିଷ
ତିନି ଲୋକଙ୍କର ଡାଲି ଆସିଲା କହିଲା
ଟ୍ରକ୍ ଡ୍ରାଇଭର କହିଲା ଯେ
ଟ୍ରକ୍
ଗଳି ଭିତରକୁ
ଯାଇପାରିବ
ନାହିଁ
ତେଣୁ
ଜିନିଷ
ସକାଳେ ସେମାନେ ନେଇଯିବା ଗାଡିରେ ଜିନିଷ ଗୁଡାକ ତାପର ଦିନ ଖଲାସି ହେଲା
and to substantiate this DW 1 and 2, but trial court
had been mentioned DW 2 and 3. No one stated that due to narrow road, the materials could not be unloaded in our.
That is not, but in the cross-examination, you should have put it. You have not put it.
Neither they have questioned in the cross-examination and neither they are all their questioning
Reason for dropping the goods in his godown is there, and 313 did say.
As per the
but trial court, unfortunately, is not dealing with that. How much you have undergone?
Your lordship, he's an old man. He was
when this incident happened?
92.
92.
Yes, your lordship.
Judgment 96. What is the
judgment? Is 96, your lordship.
What was the age that time?
That time he was 30.
Now about
he'll be around 60. 61.
let us execute.
As per the prosecution report, your lordship, he was 32 years old at the time of the incident.
32 plus now
32
and
65.
65. 65. Yes, what do you want to you want to add anything?
The DW 2 and 3, no one has stated in their evidence that due to narrow road.
That you have already said.
And so
you should have cross-examined.
But that part
you didn't put that question. Yes.
And so also at the very end.
See, the interesting fact is, Caesar, she is not disputing. She says that okay, everything is all PW evidence. She says okay, no problem. She accepts it. She is not disputing that. What she says is, Caesar and everything is all right, but these articles belongs to D1, D2. When the raid was taking place, they came, said that these are our articles. And the officer, raiding officer says that I can't help it, already we have seized. That portion that has come. And they have also filed a proceeding before the collector saying that claiming the
recover to get
claiming
the
the goods.
materials.
And one of them has produced ability also, or the consignment also, saying that see, this consignment came at 12 o'clock midnight. And in the morning, 10 o'clock, I was supposed to pick up. By that time you came and raided it. Adding to that, the why it was delivered there is explained under 313, saying that the land was very narrow. So therefore it was, and that part is not dealt with by the trial. This is the story. So, I think
keeping in mind the age of the appellant accused.
age is also so much 92 incident. Madam, your name is Massey Wells.
My name
What
is, Your Lordship, Zenish Wallace, Your Lordship. ZENISHWALLACE.
Right, huh? Okay, thank you very much.
Obliged, Lordship. Lordship, acquittal is granted.
How do you let us see?
Your Lordship is reserving it?
I have rejected it. You have done
Obliged.
good.
Obliged.
Item 12.
Your Lordship, I took on the my instance, Your Lordship is granted, they posted for today, Your Lordship. The matter was last listed for day for yesterday. But despite several inquiry before the concerned police station, IAC Digapahandi police station, whether the vehicle has been recovered from the accused, from the appellant, owner of that vehicle, but not get any response from that police station also. And one more thing is, owner of the vehicle, the former is Kendrapada. See, he is staying at Bhubaneswar, but the offense was committed with the vehicle was the appellant was committed before the under the Digapahandi police station. Therefore, it is not at all in the for the subject period could not able to get the instruction whether the IAC Digapahandi police in view of the judgment passed by the London trial court whether the vehicle has been recovered from the appellant or not. That is my also.
Where is the question of recovered? Already recovered, therefore this order.
But there is two appeal, Your Lordship, against the order of the confiscation order passed by the London trial court, filed by the owner of the vehicle, being acquitted the appellant, the London trial court directed for confiscation. That is the order challenge, Your Lordship, one appeal.
Let us see first appeal. Let's see. Yes. First appeal is
269.
269. It is against what?
It is against the order of the portfolio refusing to release the vehicle registration.
Yes. The last portion of the judgment, isn't it?
Right.
Last portion it says the seized car was engaged in the illegal, and while acquitting this finding has come.
Yes.
Seized car was engaged in the illegal transportation of ganja, as such liable to be confiscation. Hence, the seized car be confiscated to the state, and another seized car articles restored, and after the period of is over, in case of appeal and disposal, so and so, so and so. This part you are agreed,
Yes.
isn't it? And this confiscation comes after the acquittal.
After that,
Once it is once the accused is acquitted, and how this finding survives?
Yeah.
And the seized car was engaged in illegal transportation. You are acquitting.
Lordship, I kindly glance for a moment here. The vehicle is involved in the illegal transportation of the contraband ganja.
But you have acquitted,
But
saying that the case is not made out. Then how will you give this finding that it is illegal transporting?
And last year also when
If illegal transportation was there, you should have convicted.
and your lordship, last time you was directed to file with, to check whether state is free for against the order of acquittal. Only whole difficulty is that this is a case arising out in a 2BCC case. Therefore, it is not to ascertain from the Honorable High Court website whether.
I'll set aside,
Lordship.
I'll set aside this order.
Yes,
I'll set aside this order.
both the.
And so what is the second one?
But here we have, in the first one, we had challenged the refusal of release of vehicle in our favor. In the second one, the entire judgment we have challenged. The second part of the judgment, which my lord.
Why entire judgment? How are you agreeing?
The judgment in which this following observation has been made. The acquittal judgment, the following observation which my lord was just producing.
Where is the judgment dated? Here is the judgment dated. Something I missed. Six. Here also the same thing you have challenged. No, the second is see, the acquittal order is on 12/9/1996. Thereafter, on 23/9/1996, subsequent thereafter, you moved an application stating that the when seeking for release of the vehicle.
Right.
And the trial court says, since the main matter is already disposed of, I'm thankless of which I can't pass the order. That order you have challenged.
The appeals, the present appellants are the owner. And driver of the vehicle of the owner, present appellants, driver was paid the trial. Not 20B of the NDPS side. He was acquitted. So for vehicle of the present appellant involved in transportation contraband ganja.
Vehicle has committed the crime, not the driver. That's what you want.
And that
Then-
there is a specific provision into the exclusive person whether the.
If the driver of the vehicle is acquitted,
That's it.
then case goes. How the vehicle is confiscated? You say that the driver is acquitted, but the vehicle has committed the crime. That's your argument.
I mean,
What is your argument? What do you want to say then?
Kind of class from my lordship. The
Once the accused is acquitted,
lordship.
then the illegality goes. The vehicle is supposed to be released. I can understand you can say till the appeal is preferred by the state, let it be there. I can understand that. Why confiscation? Is any other accused was absconding or anything of that sort? He is only one accused. There is only one accused.
Vishal Pradhan is the driver of that vehicle.
But he was only accused in this case.
Yes, but only face the trial. Vishal driver is only face the trial.
Is the number should call. चल far. Okay. बती दो. ये कितना भी. Okay. Yes.
Both the matter disposable?
Yes.
Item 13.
I have gone through the brief manner, so it cannot be a case of acquittal. So, but period undergone, you should consider that petitioner is a lady my lord. At the time of occurrence, her age was 30 years, and if you had conviction is under 20B NDPS Act, INDPS Act, that is sentence is 1 year and fine is 2,000 rupees. She is already there in custody 3 months, 10 days, my lord. And so far points are concerned, my lord, only 2 points my lord there. One is conscious possession. As per allegation, the appellant was sit on a bench, bus stand or a bench पर बसतिला. Independent is saying the goods bag was there in the left side, and some are saying the right side, and bag contain 9 kg 500 gram ganja. 9 kg. 9 kg. 9 kg. This is the allegation. This is the sole point. Sitting bag is there, right side, left side.
What about chemical?
Chemical content.
Yes. Is there?
Right.
This is the 98 keys, huh?
98.
Apart from that, there is nothing.
Apart from
how much he has undergone?
3 months, 10 days.
3 months, 10 days.
10 days.
The
20 occurrence, 21 produce 21,997 and the release on bail 2,198.
recovery is 9 kg.
The recovery is 20 to 21,997. That is the
No,
date of occurrence.
quantity.
Quantity of the 9 kg 500.
No. Ganja. What is the minimum sentence indication?
No minimum sentence is there. At that time, no minimum.
That time it was not.
Sentence is 5 years.
Huh?
Maximum sentence is 5 years. No minimum sentence.
20 B, na?
20 B. For a term,
20 B1. Earlier it was 5 years, huh?
Well, maximum.
No, it says which may extend to 10 years. Inshallah, also be. Huh? Old book, no? Substitute, yeah, substitution.
Maximum 5 years.
20. B1. May extend to 5 years. And shall also be liable to. What is the fine amount?
Fine amount is 2,000.
2,000.
And shall also be, not only can
This
also be
is-
potential. So, ये तो हम कितने केजी था ना? केजी consider small quantity. Why that not? Small quantity कितने की? Why? 8 बोधे से पड़ी है ना? That's fine. Extend up to. Anything between 1 to 10. What is it?
Increase little bit of fine. I'll increase the fine under 3 months under gone. What is the,
Whatever will be, that was verified the.
because you were 31 years.
Now, about.
Increasing fine is also neither these people, poor people can't pay. What was the fine imposed here? 2,000. Huh?
2000.
I think.
But he has to feel the pinch of conviction also. Let us make it 5,000.
Yes. By
5,000 I'll make and period 3 months reduced to the period already gone, but the fine is increased to 5,000. Okay. इसको भी दे दो. Thank you. चलो आज काम. Okay. I'll come after this. So 12:15. But I'll come at 12:15 and give dictation. Because whatever I've heard now, I'm go and give dictation. Otherwise, it's unnecessary getting piled up, you know.
My lord, item 17 may kindly taken up, your lordship.
I'll take it up.
My lord.
Take it up. What is it?
আসছে কিন্তু whereabouts not ascertained errors. Item 10 টারে সেটা pass over ইতলা হচ্ছে.
Whereabout not
Ascertained.
what to do. Nobody appears.
No, nobody.
Nobody appears.
Yes, sir.
Persons to they'll give persons to the order dated 19/8/2025 and 9/9/2025. Report has been placed on record. As per the report, the whereabout of the appellant is not ascertainable. None appears for the petitioner consistently for many hearing. Therefore, so is appointed as yes, give us. So is appointed She is there, huh? He is appointed as an Amicus to the copy of position will be mentioned. ठीक है? वो they next interception type. ठीक है? Yes.
Item 14.
Yes. Well done. We 6 months, huh? Yes.
Five kg of lumber. So it's
6 months and? No. 2 years, 6 months is sentence. Undergone? 6 months? 17 days. Any antecedent? No. This is old act, na? Before the amendment. So 5 years was the sentence, huh? Maximum sentence. 5 kg of gun. No antecedent. So what is it? Old age? Old age. Loan वाला था. Yes. What do you say? Confined to sentence? You argue for.
Not be comparing this. It is because of the fact.
Huh.
that the
Is a case for acquittal.
Incident happened on 5/1/1990. The form C7 belongs, which is dated 5/1/1998, reflects the PR number. So it has not been prepared contemporaneously.
Let us see. He has already undergone 6 months, 17 days. Yes. And what else is there?
Here's was instituted on 5/1/1998.
5/1/1/98.
How could the PR number be reflected in the Malkana register on that day?
That Malkhana register, where is that Malkhana register? Let us see.
There is 49 marks specifically.
49. Yes, 49.
Further examination by prosecutor. I have brought the C7 register from Malkana register from my office. I have kept the seized article in the office Malkana, and accordingly I have made entry in this register. This is that entry.
Exhibit 11.
It is not a fact that Exhibit 11 doesn't bear any date. The date is 5/1/1990. I have Malkana record rocking the forward color that you can put here from cutting.
Training register and the same as register is Malkhana from. Let us see Exhibit 11. Let us see Exhibit 11. निकालो ये Exhibit 11. Exit. Where is Exhibit 11? It's 10th of course. Exhibit 10 was Exhibit 11 can. Exhibit 11 is there, yes.
Urges that he has kept the articles in the Malkhana. Then he forwarded me to court. So the TR number must have been registered after I was forwarded.
But where is TR number is not written in the exhibit.
Yes, let me not send
But
evidence.
see the exhibit.
Page 47.
See the exhibit. Where is the TR number? In the exhibit there is no TR number.
Exhibit 11. You're asking at Exhibit 11.
Yes.
In which page will not have
That is, you just you take out the exhibit 10, just next page. Copy of application number, this is exhibit here. In TR number so and so, so and so. This is exhibit 11.
Again.
Plastic bag TR.
January 98. This is the entry I am looking.
Yes, there is a TR number at the extreme left. It is written one plastic bag, TR DLT cement bag, TR number 1 of 1998 containing 500 of ganja. It is typed 1.
Yes. Now, your lordship may kindly look at what we have stated at page 45 of the paragraphs.
45, huh?
Para 6 I am lazy. A spot kotha se kahuthi. I seized the ganja and the bag above one, prepared scissor-linked exhibit 4. Read over, explained its contents to accused and witness. Admitting its contents to be correct, accused and witnesses put their signature. Exhibit such and such as the signatures. I handed over copy of scissor list to the accused, who acknowledged receipt of the same, put his signature by the exhibit 4/3. I arrested accused at the spot and examined the witnesses. I came to my office along with the accused, seized property, scissor list, etc. Kept the seized property in the Malkhana. I also entered this in C7 case register, in which the case particulars list of seized properties are mentioned. It is called Malkhana case register. I sent the detailed report of search and seizure to the Deputy Commissioner Excise Central Division to Inspector Excise EIA DP Kata. This is the office copy of the report exhibit 5. Then the examination was deferred, and this what we have stated as para 50.
Then this, there are 49.
forward entry
Say the noise. How will you explain it? See, on the same day when he was apprehended, and it was sent to Malkhana, and in the Malkhana exhibit 11, if you see, at the extreme right, TR number is written 1 of 98. And how the TR number can appear there in Malkhana register? Whether it was typed 1 or subsequently typed 1, what is that? It looks like a typed one, not the register as such. Register तो हाथ रे entry ही था type थोड़ी करेगो. यही नथिला हाथ actually जाको हाथ रे entry करती हो ये कौन करती जाको type करके TR number लिखी कि आने exhibit करे ची. ते register फेस्टर किच नथी हो. टाइप करके कागज रे TR number को जोड़ के फाइल कर दी आने exhibit कर देती हो. क्या होती घटना? If this is the kind of evidence you bring on record, then benefit ultimately goes, because these are the draconian laws. The procedure has to be followed very meticulously. It can't be ignored like this. Just see type copy आने तार मालखाना register ही नथी हो. मालखाना किसी register फेसिट नथी हो ताकू type करके आने सब लेखा लिख कर ता भीतर It apparently looks like. It is written date of application. What is this? Date of ready, date of delivery. Yeah, all these things. No? This is type copy.
And below that, my lord, we see the forwarding report. The accused has been forwarded on the next day to court. So TR number must have been assigned only on 6th of January.
That's very obvious.
So Tuesday दिन हम last week देखी.
हाँ?
Tuesday absolutely common Tuesday alert.
ये ना तो
क्या पूरी कागज से बोलती
See that? And in the statement again he is reiterating those things. And that's the problem. Otherwise it could have been ignored.
To the court in custody along with the seized property and forwarding letter.
So casually this is
The court on that day. This is the forwarding letter mark exhibit 6. This is my signature 6/1. Accused has produced before the sessions for that and Bhubaneswar along with the seized property.
Yes.
What is clear?
It is not the fact that exhibit 11 does not bear any date. The date is 5/1/1988. It is mentioned again that as per form C7, the excise minus.
No, see exhibit itself. Exhibit itself, it's see the extreme left if you see on 5/1/1998 at 4 p.m. on the road so and so so and so so and so. All these things is written. In the extreme right, TR case number 1. Continue. What he says that how come you know that TR case would be 1 on that day?
He said in the cross-examination, page 8 of this cross-examination, it is audited.
Which page you are reading?
Page 49.
Page 49.
Yes,
49
yes.
last paragraph.
Yes.
And the date is 5/1/1998, which is mentioned against that entry. As per form C7 of excise manual, we are maintaining this register. The name of the register is Malkhana Place Register. It is an audited regular. The label indicating that C7 case and Malkhana register is missing. After getting the TR number from the court, I mentioned the same against the entry.
That's what his objection is. Then the Malkhana register was prepared subsequently. On that day it was not prepared then. That is what is the allegation. Oh, you have to see once it is given on that day, there should be entry. Then if you read this and the Malkhana register is subsequently prepared.
Says that I mentioned the same.
I mentioned this
After
entry.
getting the TR number from the court, I mentioned the same against the entry.
Where is that entry ten wala? Entry ten wala is not there. The problem is it is typed 1. It was prepared subsequently. It was prepared subsequently.
Last-
पूरा मालखाना रेजिस्टर भी आना थी गोटे पेज टाइप करी गोटे पेज आनी लगे दीचंदी सेति तो वेरी सिंपल वेरी सिंपल ताकू कुआई तो रेजिस्टर धर के आसे टाइप करके
The label indicating the C7 case and mark.
therefore that is the reason the cross examination is styled like this
Missing only.
missing है करी
Still, having Mangalore to come, try to clarify.
and what else apart from this
First day.
You more than that, is demolition of the whole case. At on high.
on merits let us see Ari.
Actually,
खोलिए
Wrong mention thing on हमें 5 तारीख दिन एंट्री करते क्लियर नंबर का केमिल सके 6 तारीख पर मतलब फॉरवर्ड करो कोर्ट को मतलब 5 तारीख दिन फॉरवर्ड करता है तो तुम्हें एक्सप्लेन करता है जे हमें क्लियर नंबर का टाइप नहीं करो.
and he says that I obtain it from the court and thereafter I enter that will then he says that it is not a contemporaneous document.
the entity vicious one.
That's a different story. That's a different story. That you have to meet this argument. This is one of the arguments. What else is there?
Brazil का को फर्स्ट टाइम ये जो विटनेस फर्स्ट टाइम की
57.
है 59 57 तो है independent witness doesn't support this user because
This is the usual story.
Don't one ସବୁ କହି ଦେଇଛୁ
That's the usual. So IO is PW. Let us see the brass seal thing.
Brass କରି
Yes.
Then I bought the first jury bag from the jury bag and took the payment which came to 5 kgs. Where Ganja was kept in the jury bag, tied the mouth of the jury bag, kept it inside the first bag, tied its mouth, and I put paper seal on the bag, taking signature of the accused, witnesses and myself in a slip of paper and pasted it by means of lath, which is called paper seal.
ଯାହାର ତ କରୁଛୁ ସେ ନା
तो କରିକି ଆଉ ସବୁ ତ କରୁଛି।
ସିଲ୍ ତ କରୁଛୁ
ଆମର ତ କହିଲେ ତ ମତେ ତାରି ଦେଲା କହିଛୁ hindi କହୁଛି ଆଉ ସୁପ୍ରିମ କୋର୍ଟ କହୁଛି public prosecutor should be
50, you are pointing out section 57. 57, not complied, according to you. Not complied. Yes. And anything else? Hmm? Yes, that's a better idea. You also file a note, madam. See, his case is 57, 55 and 57 not complied. And this exhibit, Malkana register issue. This is apparently not a contemporaneous document and that cannot be relied upon. And if it is can't be relied upon, if this is taken out of the Malkana register is taken, then where it was kept, whether the scope of manipulation is writ large thereafter, whether it was kept in the Malkhana or somewhere else, or in his own possession, there are many question marks thereafter. Next day କରାଇଛି ମାନେ one day where that ମାଲ ରହିଲା କୋଉଠି 5 ରୁ 6 ଯଦି 5 ରେ ଯଦି ପ୍ରୋଡ୍ୟୁସ କରିଦିଅନ୍ତେ କିଛି ଅସୁବିଧା ନାହିଁ 6 ରେ ପ୍ରୋଡ୍ୟୁସ କଲେ ସେ whole overnight the seizure is very small quantity, that is the reason. And a huge quantity I can understand. It is only 5 kg. So there can be a scope of manipulation also. Tribal to go na hoga. Argument heard. Judgment reserved. Counsel for both the parties are at liberty to file the written note of submission within a week. Don't delay it, otherwise forget exhibit 11. Doubtful.
There is the
TR. Written. Is 54 cross examination is 54. Yes, of course. Yeah. Prepare it, huh? Give.
Fine. I understand the mismatching of the mentioning of the TR number in exhibit 11. But on 5/1 in the 1998, the entire Bandha was drafted the Mandana on 6/1/1988. It was produced before the only the mentioning of the TR number in the exhibit I have to explain, and the constables are there.
That creates a doubt. Overnight, in whose custody it was there? Malkhana, you have prepared a register subsequently. Subsequently, you prepared it, typed it out, and placed it on record. That means it was not there in the Malkhana. It was there with IO. That's what the inference is.
Yes.
Why this is apparent? This looks apparent because see, Malkhana register is manipulated. If Malkhana register is manipulated, the inference is it was not put in the Malkhana on that day. And overnight, quantity is very less, 5 kilo. Overnight, it was there with whom? Chance of manipulation is always there. That is the benefit of doubt. It goes in their favor. A slightest benefit of doubt goes, then entitled to acquittal. As simple as that. And that too, a case of 98. Why should anybody will 3 months already undergone? In that situation, better to acquit instead of. If of course you can. Of course you can. You have to. Why invite problem for himself? That is the process of learning. That is the process of learning. Yes. Next.
Item 15.
Yes, next. Anybody?
16.
देखो
15 कौन लगा कि is there anybody there or otherwise we'll appoint someone. 16. Now let us see 15. Anybody is appearing? Nobody is appearing. Whose matter is this? A report is called for.
Interception.
20B.
Page
ये कौन सा रिपोर्ट है? अच्छा यार वो गलत ना हो वो गलत ना करो थी नहीं होगा करो थी विद्याधर प्रधान निरंजन कानूनगो महापात्र कहना अच्छी पदलिस्टे कहना अच्छी
विद्याधर प्रधान निरंजन कानूनगो.
Next to you were of non APS for the appellant. In the interest of justice, adjourned to next week or and in event non APS for the appellant, and amicus curiae will be appointed. Next data. Yeah? That is okay. Next is
16.
yes. Yes. Yes.
Outpost as police constable on that night. OIC Jharpada PS Constable SM Rao and myself, ASI went in a jeep patrol duty. At about 2 a.m., we found near Talukada, accused was coming carrying a bag. Being questioned, he replied that the bag contains nothing. The bag was searched by the OIC. The bag contained ganja in jelly bag. The recovered ganja was taken to the shop of our vegetable shopkeeper. When it was weighed, the weight.
1 kg, yeah? Yes. Separately. Yes.
PW3 numbers. Paragraph 6.
Paragraph 6. Yes.
When he is stated, myself and Constable M.T. Barsaki went in search of the accused. After reaching CS, I cannot say where and in whose custody the CS ganja was kept. I merely saw the seal of the OIC, but I did not see whether it contained the seal or any other mark. I do not remember if there was any writing of keeping the seal in Sima of Wabula Pradhan, but I did not sign any such document. I did not sign any paper at the spot. In the senior
Yes. Second para. All the C's articles.
who has paid. And was paid at the spot. And the 5 kg.
They said that the spot.
Thereafter,
I have not signed any paper. Correction.
After was kept separately at the PS, but not kept together. After detection at time of writing documents, the accused fled away. I cannot say what writing was going on. Signature of the accused might have been taken, but I have no knowledge of it.
Might be taken, but I have no knowledge about it. It's not a fact.
We detected the accused at about 10 a.m. We searched for the accused for 10 to 15 minutes. After seeing the accused, we straight went to PS through Hariguda outpost. We reached PS at about 12.
Yes.
Whereas in the fire, stated that the information received at the police station has been the time has been mentioned as 8:30.
Morning 8:30. In a fire. 8:30, he was apprehended or the FIR was registered? What is that? 8:30. Incident.
The incident after the FIR is 6 a.m.
8:30. Information received 8:30. Occurrence is 6 a.m. occurrence at 6 a.m., 8:30. Yes.
PW5, page 48, first examination. Paragraph 5, the contraband article was made putting out from inside.
1 minute, 1 minute. 5, no?
Yes.
Yes. The contraband article bring out inside the bag. Inside the bag. After packing and sealing.
Kept inside the bag. The rest of the contraband article was seized after keeping inside the bag, except the seizure list. No other list of documents was written for taking different articles to the police station. Paragraph 6. No entry either in the register or paper was made by the OIC for getting information that contraband article was being taken by an unknown person. There was signature of OIC on the seal, which was affixed as stated on it. I do not recollect exactly on how many places the seal was done.
All these things you are showing for the purpose of 57. Section 57. Yes.
Stated that the case came to be 1 kg rather than 5 kg as the defense stated.
PW1 says 1 kg, yeah?
PW2 is an independent.
PW2 says PW5 also says 5 kg.
PW1. This was the vegetable vendor from whom they have asked for PW2, who was a witness to the said seizure. And he has not supported the prosecution. That no seizure has been made.
What PW1 says, independent is got in a PW2, where it was weight was
From the bottom.
yes. Sample 100 gram. Where it was weighted.
28,795. I was attached to the post responsible. On that night,
In the vegetable shop.
yes, ma'am. They recovered
For weighing it was taken to vegetable shop. Whereas this other witness says that it was done in the weighted PS. PW. PW2 says PW2. Yes.
PW, be silent with regard to where the measurement is taken place. He does not state anything with regard to
Oh, PW?
3.
PW3 doesn't say anything. Yes.
PW, so they were measured and weighted at these.
No, PW3 just see para 2.
Yes. He says that it's how he was carrying ganja. Why he sent myself in the DFI? He's weighing vessels from Calcutta. We bought this. The ganja was weighed when it came to
That weighing machine was brought from Talapata village. That's what he says. That means if PW3 and PW4 corroborates, because they say PW4 says that it was done in the PS and weighing machine was brought by PS. PW3 says it was brought. What PW2 says? It was done in shopkeeper, Bhagya Pradhan.
Being questioned, the accused first disclosed that he was carrying some clothes. Now, this has happened in fact at the spot. He was detained at the spot. He disclosed that he was carrying some clothes. Then he was asked to answer this. It was found he was carrying ganja. OIC 10.7 and KSI to bring weighing machine from culture. We brought the same. So it has to be at the spot market.
It looks like. But PW2 is version is completely different. Yes. Yes. What IO says regarding this? PW6 is IO, huh? Three, I am reading that only. Then according to him, it was done in the spot only, not the spot only.
One, the case number is missing. The seal impression is also on MO1, but seal was broken and paper slip was damaged. The MO1 there is no on MO1 there is no paper slip and it was destroyed inside the mud. Now the signature is not in MO1. In paper slip it was written XTA, signature of abuse, witnesses and my signature and also seal. I cannot say how many impressions of seal I gave on MO1 at the time of its seal. MO1 is already told and there are holes, but when I handed over MO1 to sections court, it was intact. With the paper slip, a fixed number. I have taken one paper slips, one for everyone, one for the sample. I have taken only 100 grams of ganja from the
Yes.
The serial list I have not mentioned the mark A and P by 1. And from the serial list at column 10, I will mention that one chocolate butter that containing 5 kg of ganja was seized in its description.
Apart from these contradictions, what else? PW2 only contradicts, otherwise all the witnesses are consistent.
Regarding the next where the has been taken with regard to the quantity. Even the higher.
Quantity, only PW2 says that 1 kilo and the other witnesses, all of them are saying 5 kilos. Except PW2, all other are saying 5 kilo. That's not replaced. And PW2 only says that it was done at this, no, PW4 says it was done in the PS, and all other witnesses say that it was done. That these are the minor discrepancies, except that. What is the sentence here? Sentence is here is 2 years, yes. Undergone period?
Seven,
27? So, final form निकालो यार, final form. 16 ना final form निकालो. Where was arrested? The column it is not even mentioned. Proceed. Go ahead.
Twenty-eight, 699 order lots of times. Order of the High Court. 28, 699 order of the High Court.
28?
699.
26. Yes. 99.
In the meantime, to pass.
Petitioner being found guilty of so basis with generation so it is born out of the court that the petitioner surrender before the court also and should be for less of the factors since the petitioner is language on the bar. In the meantime, more than 1 year has lapsed, taking to period of detention. I'm inclined to 1 year already undergone there.
Again.
1 year. Date of arrest after the judgment. Reports. Petitioner surrender before court. Surrender before court is on 29/4/98. Surrender. And bail on 28/6/99. Order bail. More than 1 year is left, taking into account sponsor, petitioner will release on this furnishing 20,000 response. During trial, what is the situation? Absconder. It should NBW. Accused is absent, accused is absent, accused is absent, is absent, absent, accused absent, accused absent, absent. Produced. He was arrested.
I will say 29,795.
29,498.
29,498.
29,498 arrested. 29,498. When the judgment was passed?
29,499.
28,699 he got the bail. Isn't it? Surrendered. Bail or judgment 29,499 judgment. Okay. Huh? One more? Yes.
At about 6:30 AM. The date of incident and the date of being received at the PS, it is at 8:30. But the date of dispatch from PS, 3799. There is no explanation provided with regard to the delay of dispatching the FIR to the magistrate.
When it was dispatched according to you? 30?
7. The next day it has been dispatched.
31/7.
No, 30.
29 morning.
No, 31/7 it was received by the court. 31/7/1995. How much delay then FIR is on? 29. 31 it was 2 days after. 2 days after. Yes, you give written note. That is the judgment argument heard. Or should not think though, and the judgment reserves written note of submission within a week, not beyond that. Within a week. I can take 1-2 metro only today.
Same time. The counter piece is also listed together. The counter appeal. The offences are pertaining to 324 in Alimony of the ASPs. In the meantime, at the first appellate stage, the involved parties have entered into a compromise. So we wanted to hold that counter.
20 and 48.
20.
20 and 48. Oh, you just give it, list all the matter together. Thank you. Yes.
27.
Item
27, sir. 27.
27. Sole appellant. Sole appellant. Sole appellant. Babula, alias Ramchandra, Jena. Expired or 7/1/2000. In the absence of some sort, waiting.
Yes. Item 17.
Wait, please, Your Lordship. I am audible, my lord.
Yes.
My lord, in this case, Your Lordship, the appellant was convicted under 20B1 NDPS Act for alleged possession of 3 kg of contraband ganja and sentenced to undergo RI for 3 years, and the fine amount is there, Your Lordship. There is, my lord.
How much? 3 kg.
3 kg, my lord.
Undergone period is 11 months.
11 months, Your Lordship.
kg, 11 month undergone.
Yes.
My lord. My lord, 3 point is there, my lord. 1 by 1, I am 70.
Already undergone, I'll convert. Will you be happy or acquittal?
Acquittal case, my lord. It is pure acquittal case. Why I am saying, my lord?
Okay.
There is 2 witnesses examined. PW1 is the IO.
There are only 2 witnesses,
Yes.
huh?
Only 2 witnesses. PW1 is the IO. Examined as PW1. He is the informant in this case. He was the person who allegedly detected the contraband ganja. He seized it. He weighed it. He sealed the contraband. He submitted the charge sheet, my lord. And one independent witness, he turned hostile.
Okay.
The only statement before the learned court below is statement of the investigating officer only.
PW1. Yes, I agree.
PW1.
I agreed, my lordship. Because of the PW1, my lordship, whole case has been.
Let's see PW1. PW1. Let's see PW1. What does he say?
Starts from page number 36 of the paper book, my lord.
36, huh?
37.
Okay, 37, yes.
Paper
Let's
book.
what he says.
I will read, my lord.
Yes. I have been posted as SI so 98 I found the accused near travel crossing coming from down foot side towards from Pukini. Anyway, the accused was also site and was trying to run away. Suspecting that the accused may be carrying the narcotics, I decided to detain him. I called to passerby to join us and search the accused. And one of them named is Sukanto Sahu.
PW2 was alone.
Sukant Sahu is PW2.
2 was alone, willing to be a search witness. I gave my identity as a sub-inspector of excise and my intention to search him and give him the option to be searched either before the nearest magistrate or a gazetted officer of the department. I served a notice to that effect to him. Exhibit 1 is the notice under section 50 of the NDPS Act, served on the accused. Exhibit 11 is the signature of the accused. Acknowledging the receipt of the notice, Exhibit 1 is the carbon copy of the original notice served on the accused. The accused preferred to be searched by me and endorsed it in writing in a separate paper. Exhibit 2. 2.1 is the signature of the accused thereon. I then proceeded to search the accused in presence of the search witness, Sukant Sahu, ASI, and Constable, my lord. 3 persons are there. One is Sukant Sahu, who is the PW2. Another is
ASI and Constable.
Not examined in this case, your lordship. On search, I found the gunny bag carried by the accused contained ganja, cannabis. I weighed the ganja and found its quantity to be 3 kg. From my long experience in excise department and specialized training in narcotic, and from the smell, color, and texture of the content of the gunny bag, I found it to be ganja. I seized the gunny bag containing ganja. Scissor list is Exhibit 3, and the Exhibit 3(1) is my signature on. Exhibit 3(2) is the signature of Punch Witness Sukant Kumar Sahu. Exhibit 3 is the signature of ASI Buddhanatha Sethi. I also took the signature of the accused on the seizure list. Exhibit 3/4. I read over the content of the seizure list to the accused and witness before taking their their signatures, and made over a copy of the
Punch witness is not examined.
not examined, my lord. Only one person is there. Thereafter, I'm reading the para 6, your lordship. I stitched the gunny bag with thread and sealed it by means of paper slip, contain the signatures of the accused, punch witness, and official witness, and seal it by my seal. I put the specimen impression of the brass seal on the seizure list. I kept the impression of the seal in an envelope and sealed the envelope. I made over the brass seal in Jima of witness Sukant Kumar Sahu. Under Jimanama, Exhibit 4, Exhibit 4(1) is my signature, this and this, Jimadar Sukant Kumar Sahu. I disclosed the ground of arrest. The accused before effecting arrest, I took the accused and seizure articles to the excise office and prepared the relevant document for forwarding the accused to the court. Exhibit 5 is the sketch map of the spot prepared by me. On very day, I produced the accused before the special judge, Session Judge Bhubaneswar, at 5:50 p.m. Prayed to draw sample of the seized ganja for the chemical examination. The accused was remanded to judicial custody and asked for the direction of the special judge. Seized ganja before the SDG Bhubaneswar on the same for endorsed of sample. The learned SDGM drew sample of 50 grams of ganja from the seized ganja and handed over the gunny bag containing rest of the ganja to me for depositing in the court Malkhana. I produced the rest of the ganja in the court Malkhana. On the very day, wide Malkhana challan number. This is also important. I will draw your lordship kind attention. The SDGM made over the sealed sample packet along with the forwarding report in duplicate to me to produce it before the state drugs testing laboratory for chemical examination. I could not produce the sample before the state drug testing laboratory on the very day as the sample was handed over
Come to page
me.
42. Come page 42. Para
My lord.
16.
I had kept the sample in my custody. That is, my lord. I have kept the sample in my custody from 10 p.m. on 26.
Full one day.
My lord, full one day, overnight, your lordship.
Till morning.
Because that
Overnight.
Till morning.
clarify because that ganja was handed over to him at the late night, what he has said. Because of the SDGM has given handover.
No, 10 p.m. He says that from 10 p.m. on 26 to 10
Overnight only.
Whole night.
Overnight. Overnight. When I deposited it in the state drug testing laboratory, it is not a fact that I have tempered seal of the sample. I have not mentioned the time of depositing the sample in the laboratory in my case diary. It is not a fact that I have not complied the requirement of section 50 of the NDPS Act and that exhibit 1 is not the proper compliance of the aforesaid provisions. It is not a fact that the content of exhibit 1 were not read over to the accused. I, along with ASI, the constable went to patrolling duty, this and this. City that as the accused was at our site and I suspected him of carrying narcotic, but I have not stated it in a separate sheet. I have not obtained the signatures of the witness or the accused in the spot map. It is not a fact that exhibit 4 is not the proper Jimanama and that no brass seal was made over to the witness Sukant Kumar Sahu. It is not a fact that MO1 was not seized from the accused one. It is not a fact that I have falsely implicated the accused. Again, re-examination, the sample ganja was sealed by...
Sukanta Sahu turned hostile.
Yes.
Turned hostile, my lord.
One thing
So
I want
only...
Yes, my lord.
Let him complete. Yes. Only one witness there.
Only one witness, who is the complainant here in my lord. He is the detecting officer, he is the seizing officer, he weighed the contraband, he sealed it, he arrested the accused, subsequently investigated the case and filed the final form.
One man show.
That's why, my lord.
One man show.
One man show, my lord. That's why, my lord, I will rely Mohanlal, but my lord, Mohanlal not subsequently entirely. The only part is Mukesh Singh versus State, where the 5 judges bench, my lord, reaffirmed the principle that while it may not be an absolute bar, in cases where the prejudice is caused to the accused, such duality of roles is fatal to the prosecution. But, my lord, in Mohanlal versus State of Punjab, it was categorically held that the informant and the investigating officer must be the distinct person, failing which the trial stands vitiated, Your Lordship.
What was the Mohanlal? What was the case? NDPS?
NDPS, my lord. Mohanlal versus State of Punjab, 2018, volume
minute.
17.
2018?
Volume 17. SCC 627. It is a 3 judges bench order, my lord.
Okay. Para?
Paragraph. I will submit a written note, my lord. Where 2 pages written note, my lord. It will clarify my things.
Okay.
And
Okay.
Mukesh Singh is a 5 judges bench order, my lord.
Give it by tomorrow.
My lord, by tomorrow, Your Lordship.
And what else?
Next point, Your Lordship.
Nothing is to read, only one.
My lordship, the option was given to the accused. Whether it was exact, my lordship, in the last part, it was as the exercise his option to be searched by one of the aforesaid public. My lordship, the option was given whether you have to.
Section 50 option?
Yes, but it didn't have it.
I am not disputing section 50, my lord.
I will search before that.
Has it been exhibited that?
Yes, exhibit 1.
Exhibit? All these things are, printed thing. Formality, 50 notice endorsement.
Everything has been
I'm
followed.
not disputing section 50, my lord, but section 50 to 55.
Exhibit 1 is the 50.
What is the period undergone?
11 months, Your Lordship.
11 months.
26/10/98 in custody, arrested, and 39/99 was released.
Okay, you give
Hello?
a written.
52 and 55, my lord. Improper sealing and custody, sample kept overnight at officer's house, chain of custody broken. Section 57, delay report, report sent 10 days after seizure without explanation. That part and the investigation part, my lord. 3 points.
Seal part is also, my lordship, it is there. The chemical examination has proved that the seal was in the, when they have taken charge of the chemical report, the seal was same seal in the, before the magistrate. They have given this. In exhibit 10, my lordship. Because the chemical examination in his report exhibit 10 has testified that the seal on the sample was intact and identical with the specimen seal received from the court on the forwarding memo. Exhibit 10.
Then the chemical report unproved, chemical examiner not examined. Report need to be proved under section 293 of the CRPC. No one is examined from the side of the chemical examiner.
But it is proved, my lordship. It is exhibit.
Chemical examination, nobody, you have not examined also.
Yes, my lordship. But it is the fact that they have proved that the same thing has been There, my lordship.
You have to adduce the evidence of
PW1,
the
everything
examiner.
is exhibited.
Yes, my lordship, that part is.
Everything is exhibited through PW1.
Brass seal, my lord. Also brass seal. So for the safe custody is concerned, brass seal, my lord. Two statement is crucial in so for the brass seal is concerned.
Paper seal, and it remained with the custody of PW1 for overnight. And NDPS case, only one witness examined, and you want. Okay, judgment.
Your lordship is well aware, my lord, section 54, presumption arise only after lawful recovery.
Give in.
I will give the note, my lord. I will give the note.
But don't delay it. Give it tomorrow so that I can.
Tomorrow, my lord. Noor Aga versus State of Punjab, my lord.
Mohanlal and that paragraph also.
Mohanlal, Mukesh Singh and Noor Aga versus State of Punjab, my lord. Regarding 54 of NDPS Act.
Third, Mr.
Grateful,
T. Sahu, Lieutenant Counsel for the Amicus, Lieutenant Amicus, and Sarita, judgment trigger.
Grateful,
Yes.
my lord.
Item 20.
Thank you.
22.
The appeal has been filed, challenging judgment.
This should be the last matter. Because I don't want to. Today I get the 7 minutes. What is this case?
The appeal has been filed, challenging his judgment of 12/5/1995. The conviction is
4 months.
11 months. Section 3(1)(x), 4 months, and 323(34) IPC, 1 month, and 341(34) IPC -1.
But everything will run concurrently.
Mine.
So then it's 6 months only.
Mine. And he has arrested on 29/93. 29/93. And remain custody for 20 days, madam.
29 means 23 no?
29.
48?
No, 93.
No?
93.
93 arrested. And bail?
And we have remain custody for 20 days.
When you was admitted to
No, there is no record, my lord, sir. I have ascertained from the client, my lords. But we have remain custody for 20 days.
And after the appeal was filed, and
actually the informant and the opposite PW5 mallards, actually they are not SC/ST, they are the Christians. According to my lords, page 62.
1 minute.
Of the
page 62.
My lords. 62 of the paper.
Yes.
The IO has not examined whether they are Christians or Hindu. As it reveals from the cross-examination.
62. Yes. Which
and
paragraph?
the injury is in minor.
Which paragraph?
My lords, 62, paragraph 4, my lord. Page 63.
Yes, read it.
And he was arrested on 20, forward around 21/9/93. My lord. And page 65, my lords. My lords, the paragraph 11, my lords. I have not examined any document with regard to the caste of PW1 and his son. They are Hindus, not Christians, but they are residing within the Christian
They are
family.
Hindu
Or Christians.
Not Christian.
My lord.
I have not investigated with regard to the ownership of MOTs. Is there any certificate or anything?
No, my lord. He has not investigated regarding whether he is a Christian or Hindu. No examination has been made by the IO.
No. Who is the victim? PW?
Well, PW1 and 5. PW is the informant, PW1, and 5 is the victim.
5 is the victim.
My lord.
They are related or what?
My lord, son.
Father and son.
Man.
Let us see what they say.
And also, my lords, kindly see para 68, my lord.
Water from the well, accused Naveen came there and told, don't go.
Also,
Saying he gave a push. Yes.
PW1 paragraph 2 would be relevant.
1 and 5. 1 is the informant and 5 is the summary. So have a glance to page.
How the caste certificate, anything is proved on record?
No, nothing has
It's the evidence of PW1 to 5.
I mean 5.
1, 2, and 5.
One you want to read? 1.
1. Replace the 1.
Yes. Relevant party.
Yes. My son, Chandrasekhar Bidika, went to the government to take bath, and after him, I was proceeding to my paddy land, and I found that under banyan tree near that, well, my son was lying on the ground, having legs and hands tied, and accused there was standing on his abdomen and dealing fist blows, while other 2 accused persons were pressing his hands and legs, and accused Navin was shouting, yes, abuse in language, Your Lordship. My son was also, in that Lordship, he has assault attributed to regarding his caste. Kindly see the page 40.
Caste, Dumbo and everything is all right. But what is the evidence to show that he belongs to that? Because the IO says that he is Hindu, not Christian.
Yes, not the caste certificate was not produced, Your Lordship.
Then?
Bishop, the PW 1 to 5, their consistent evidence.
That has to be established on record.
Yes, Lordship. In the cross-examination as well as in the 313 statement, they have not elicited anything that I'm not belong to the Christian.
But it is the prosecution who is to prove.
Should have been like the caste certificate as well as of the victim as well as the informant, the both should have been on the record.
Come to 47 page. I am a Hindu. I am a Christian.
I am not a Christian. I am a Hindu. It is not the fact that I am Christian or Catholic sector. It is not the fact that the date of occurrence, the Ganesh Puja was being observed on the street of Sanso. That about 7 a.m. accused Navin was disturbing Prashad and Sanso. Myself and my son witnesses went there and forwarded the accused Navin. It is not a fact. PW1 in the first para itself, he says, I know all the accused persons. They are my co-villagers. Occurrence took place 1 year, 6 months back on Monday at about 7:30 a.m. I am Dumbo by caste and member of the scheduled caste. The accused persons are not members.
Where are you reading?
PW1 first paragraph.
Oh, that I read.
Yes, sir. He says he belongs to the Dumbo.
They are saying it's all right.
Yes, sir.
They are saying will not make them unless you prove it otherwise.
So there is nothing on record to dispute that. In the cross-examination,
Dispute is there. Hindu, Christian, what is that? Catholic and everything is come on record. There is a doubt. Now the certificate should have been there.
They could have produced the certificate also.
Under the act, you have to establish.
Yes, sir. That he
is under conviction under 31X.
3110 and 323.
323 is there.
323 is there. Injury reports are there.
The
Injury reports are there. Doctor's evidence is there. Even that
20 days undergone 323 maintained and
resolution.
Yes. Convictions 31X.
Who is doctor?
PW 7.
7. PW?
7.
7.
So 7 is the doctor, and injury report is PW exhibit number 4 and 5. MO1 is the weapon of offense.
Exhibit?
4 and 5, Your Lordship.
Okay, undergone, huh?
Yes, Lordship. And the MO1 is the weapon of offense seized.
Already undergone. इसको दे दो यार अभी करा दो चलो भाई it's a furnace material here अभी रख लो देखिए 1 minute yes Mr. Furnace
item 64 Miller
64 yes thank you and appearance papers okay there yes what happened in
64 Miller
Extension
my lord granted in respect of Miller 2 appeal. One conviction, same day arrest, everything same. But in connection with Miller subitem, everything. Santosh my lord enlarged. 505 Miller, Ramananda Chaudhary.
Ramananda Chaudhary.
My lord granted 3 months interim. Keeping in the view of the custody, 1649 days, near about 5 years, 10 years conviction. And in the meantime, Miller, last week, our Honorable Court also, Miller, judgment, Miller, in a case of pendency of appeal in favor of the 389 bail, this Honorable Court granted Miller consider the bail application. Only conviction, Miller, 2 years in there. 2023, 10 years conviction.
10 years sentence.
10 years sentence.
In this case.
In this case.
And 2 years under. But in your case?
10 years conviction, 5 years more about custody.
And what about Santosh?
Santosh, same day, so everything same. Same day arrest, same day Miller conviction. My case, Miller, 35 acquisition, possessioning 35 days. Here I am not praying for bail also, Miller. My lord, in Santosh case, my lord, pendency of the keeping in view of the long detention, my lord granted only 3 months interim bail. Also relying on the judgment of the Honorable Apex Court. And now, my lord,
the appellant is inside the custody of front and
I'm praying, my lord, may pass same order. And after my surrender, my lord, will hear my appeal, my lord, in final hearing. Of course, this appeal also, my lord, earlier part had, and non-compliance of the section were there, minor also reflected in this.
the appeal is pending since 2024.
That appeal.
Here in this case, the Ajay Rajan
some
case there are non-compliance of 50
no,
and all.
in our case also same, also my lord hardly partly had. But I am not praying for bail also. I am only praying for considering, my lord, long detention in bail. for a period of 3 months. And Santosh case, my lord, also passed interim bail 3 months, not bail.
So when I passed this out,
18/20/20.
25.
let him surrender, then I'll give.
No, it was comply.
Do not comply.
Child,
In Bihar there is election, you go and you both are from Bihar. What do you say? 3 months I have given him.
Yes, my lord.
You are not able. Both of you will go together.
Election का solve
Better. Because very. Hey, that's right. I have given to one, then the other is also entitled. Not that you are not entitled. So who knows, he will be a MLA, maybe chief minister. We'll let him go for 3 months. Huh? Petitioner is
everything same, my lord.
using FIR also, along with one Santosh, same FIR, same others. Huh? Along with one Santosh Singh. Both the accused persons have been convicted by the trial court, by the judgment dated so also, and sentenced for offence under second so and sentenced to undergo RI for 10 years.
10 years.
And fine. How much? And
1
fine.
lakh.
Fine of rupees?
1 lakh.
1 lakh. In default in making payment, they have been further sentenced to undergo RI for default sentence. Default sentence.
Default sentence near about 5 years. 5 years.
Default sentence. Non-payment of default.
1 year.
1 year. 1 year. By order date 18/9/2025, the co-accused Santosh Kumar Singh has been enlarged on interim bail for a period of 3 months. By taking into consideration the fact that he has already undergone a period of about 5 years. The petitioner is also similarly situated. Therefore, Mr. Pandal and counsel for the petitioner is seeking similarly in case of the present petition. In this case, any report was sought for?
No, report was not sought.
Then I'll have to call first report then. I have relied upon report.
The conviction judgment is reflected in custody. Custody Miller. The judgment Miller.
No. He's pass whether antecedent also. The call for antecedent. You have antecedent. Insofar as Ajay Ramananda Chaudhary. Let's see.
Yes.
If you have antecedent, what this was have now?
No antecedent. If manual also desire on verification also I know.
Antecedent is there?
No, my lord, report is not. Yes, my lord, they have no antecedent. my lord. But in other case, my lord, Santosh Singh, there is.
No, this is regarding Santosh Singh.
Santosh Singh, when next item, my lord.
You have to get it right. Then twin condition has to be satisfied. No, therefore, in the case of Santosh Singh, this court has sought for a report from the jail authority regarding the conduct of the said convict and regarding the antecedents. And in that case, the district jail Balangir, while its report dated 15/9/2025, had submitted a report. Relying upon the said report, the co-accused was enlarged on admitted to interim bail for a period of 3 months. 3 months. In view of the aforementioned, the district jail Balangir, he is also in the Balangir district jail superintendent district jail Balangir. He is directed to submit a report regarding the present petitioner, namely Ramananda Chaudhary. Ramananda Chaudhary. Leaves the matter on within a week. Within a week. Leaves the matter on next Thursday. और बाकी अभी दीदी